Cleaver and others v. Schyde Investments Limited 2011. The parties had contracted for the sale of land. The purchaser secured the rescinding of the contract for innocent misrepresentation. A notice of a relevant planning application had not been passed on by the seller's solicitors. The seller appealed, saying that the judge had been wrong to find that Condition 7.1.3 of the Standard Conditions of Sale failed under the 1977 Act. The appeal failed. There is nothing self-evidently offensive, in terms of reasonableness and fairness, in a contractual term which restricts a purchaser's right to rescind the contract in the event of the vendor's misrepresentation to cases of fraud or recklessness, or where the property differs substantially in quantity, quality or tenure from what the purchaser had been led to expect, and to confine the purchaser to damages in all other cases. That is a perfectly rational and commercially justifiable apportionment of risk in the interests of certainty and the avoidance of litigation. Longmore L.J. said, "This case is a good example of the width of the interference with freedom of contract generated by Section 11 of the Unfair Contract Terms Act 1977. My initial reaction was that a term restricting rescission, in non-fraudulent cases, to instances where the property differed substantially in quantity, quality or tenure from what it had been represented to be was, in general, a reasonable clause. The Law Society, with, of course, no axe to grind on behalf